I would like to welcome everybody to the 2022 Judy Stinson Seminar and Lecture, webinar style. For those who didn't join us last year was our kickoff seminar series that was created by our then Dean, Doug Sylvester, to commemorate and celebrate really all that Judy Stinson has done, both for the legal community at large and for our local legal writing program here at Arizona State University. One of the things I remember him saying last year in his introduction of Judy was that when she started the legal writing program, it was 3 people with 60 students each and no upper level writing. And she brought it to where we are today. I won't take you through the whole journey, but we're now at 13 folks. And we have 7 upper level writing classes for the fall. So that's an amazing journey. We thank you, Judy, and we're so glad that we're able to celebrate with you all of the things that you've done and really hear some interesting developments and ideas and theories with the folks we have chosen to headline our series here. So before I turn it over to you, Judy, to introduce our speaker for today, I just want to remind everybody that the Q&A function is available below for you to type your questions in. There will be time for a few questions at the end. And with that, I'm going to turn it over to our friend and colleague, Judy Stinson, to introduce the webinar for today.
Thank you. Hi, everybody. I would first like to thank ASU. I'm very honored that this lecture series was established with special thanks to Associate Dean Tamara Herrera. This was her brainchild and she figured out how to make this work and run it, and I'm very appreciative. Also very appreciative to Professor Andrew Carter for his work this year on making things move along smoothly and coordinating it all. And thank you all for being here. I still remember how busy a time in the spring this is. So thank you for taking time out to be here. Although my middle child is home from college for spring break, and he said when we were talking about this, he said that my boys would all agree that if any of you knew what a real Judy Stinson lecture was, you would not sign up for it. I'm hoping this is not one of those moments. Anyhow, I do appreciate you attending. I was a ways into my career before I discovered how much fun scholarship can be. And it took a lot of help and encouragement from a lot of people to get me there, many of whom are here today. So thank you. Thanks also, obviously, to Professor Melissa Weresh for giving this lecture and for setting such a wonderful example for all of us as a scholar, a teacher, and a contributor to the field of legal writing. She really is just such a role model in every aspect of being an amazing professor. Okay, and with that, it's my great pleasure to introduce Professor Mel Waresh. She's the Dwight D. Opperman Distinguished Professor of Law at Drake University Law School. She has extensive honors and leadership roles, which most of you probably know, but to highlight a few, she received the Thomas Blackwell Award for Outstanding Achievement in the field of legal writing. She served as president of the Legal Writing Institute, served as an editorial member, board member of Legal Communication and Rhetoric, J. Alwyn. She chaired the ALS section on teaching methods. Mel's a prolific scholar. Her presentations are always insightful and engaging. I've known her for years. I worked with Mel when she was on the LWI board and I was on the Alwyn board. And when any situation came up, whether it was in a meeting, just a conversation, a listserv post, etc., that was getting out of control, Mel was always the calm, cool, collected voice of reason. We spent many late nights, often in hotel lounges, chatting about work, family, and life. Mel's simply one of the nicest people I've ever met. Always has a smile, always a word of encouragement. I've always respected her, and I always thought that when I grew up, even though I'm older than Mel is, I wanted to be Mel Waresh. I'm privileged to know her and very grateful for her being willing to share this lecture today. So please join me in welcoming Professor Melissa Weresh.
Well, that makes it very difficult for me to start. I might need a tissue. I do want to start by emphasizing what a tremendous honor this is for me. I have known Judy for many, many years. She's been a dear friend and a very generous mentor to me over the years. As you all know, she is a treasure to the legal writing community. And I think it is so fitting that ASU has chosen to honor her work in this way. So I want to thank ASU and in particular Tamara Herrera and Andrew Carter for all their assistance in the logistics and planning for this event. I really, really appreciate it. I chose to present my Threshold Concepts paper today in recognition of Judy's longstanding commitment to student learning. I have her book here with me now. Threshold Concepts theory, as you will learn, is a pedagogy that focuses on identifying areas where students struggle. The theory recognizes many aspects of that struggle, including cognitive, but perhaps more importantly, affective obstacles to student learning. In Judy's book, The Tao of Legal Writing, she recognizes and identifies struggles associated with lifelong learners of legal writing, encouraging us to find the way in the Tao sense. And similarly, Threshold Concepts theory recognizes the often overlooked affective dimension of student learning, and I think is therefore in keeping with Judy's keen focus on the learner. So in the presentation today, we'll start at the beginning, which is a very fine place to start, I am told. I first learned about Threshold Concepts theory in 2011 at a Drake workshop titled Emerging Pedagogies. Our group was focused on evaluating what it is that students acquire when they invest in a bricks and mortar education. So we began our discussions at that time, and it seems like quite a long time ago, with what changes and challenges were facing higher education. And at that time, one of the most critical was the increasing availability of online information. So our goal was to try to determine what it is that students get when they come to the university or to the law school. What do we as educators provide to students that they can't get from some cheaper online alternative? So we studied several emerging pedagogies that seemed promising in the context of advancing student learning and that were focused on methodologies that we as instructors can provide. So we examined problem-based learning, team-based learning, and threshold concepts theory. And I found threshold concepts theory to just be intriguing. At that time, very little had been written about threshold concepts in law or in legal education. And the theory or the framework really got me thinking about my course, my curriculum, and my students, where they get stuck and why they get stuck at certain junctures. So today, I would like to try to define what threshold concepts are and explain how they differ from what we think of as core or key concepts. I want to try to explain how a focus on threshold concepts may differ from the way in which we as educators have traditionally approached our curriculum and our teaching. So often we tend to focus on coverage in our curricula, and that can result in what threshold concept scholars have referred to as the overstuffed curriculum, a curriculum that might cloud these essential threshold concepts that have been characterized as the jewels in the curriculum. We also may approach our curriculum and our teaching, obviously from the perspective of disciplinary experts who may have a vague rather than focused understanding of where our students are likely to struggle. So I want to provide some examples of threshold concepts in other disciplines, and I'm going to propose a threshold concept in legal education. We will test that threshold concept against the characteristics associated with threshold concepts. And we'll talk a little bit about what the implications of identifying a threshold concept in legal education might be. I want to tell you briefly about a very exciting project involving threshold concepts that we're working on in the legal writing community. And I'd really like to hear from you all, what you all think might be threshold concepts in law, in legal education, how these might be useful. So you might be wondering at this point, what is a threshold concept? The term, the concept, the idea, the framework, the theory, I'm going to use these interchangeably. And there has been some criticism in the literature as to what this is. Is it a concept? Is it a framework? I'm relatively untroubled by that distinction, but the idea was first proposed in 2003 by two economists, Jan Meyer and Ray Land. They were working on a project in the United Kingdom that was called Enhancing Teaching Learning Environments. And the project involved groups of academics across the UK. And it was designed to develop conceptual frameworks directed at the quality of learning achieved in higher education institutions. And I think that's important. So the project was enhancing teaching learning environments. And the idea was to develop conceptual frameworks directed at the quality of learning. Meyer and Land asserted that there are certain core processes or ideas that exist within any discipline, but that while they define a discipline, they may go unnoticed or unspoken within the discipline because they become so ingrained. They're so much a part of our discipline that disciplinary experts may not even recognize them as threshold concepts central to the discipline. Nonetheless, they're central concepts that we need our students to understand and to put into practice because they are what enable our students to begin to think and act as disciplinary experts, as economists, as biologists, as lawyers. So this was the first definition offered by Meyer and Land back in 2003. And I find the imagery of the portal or the conceptual gateway to be powerful. We'll return to these ideas when we begin to look at the ways in which researchers have examined how students cross through these thresholds or go through these portals, but this was the original definition of threshold concepts. When Meyer and Land proposed this idea, this theory, this framework, it really ignited a great deal of scholarship. People were enthusiastic about this idea of threshold concepts, and many definitional criteria or characteristics were proposed. And I will acknowledge that that has also been a criticism of the framework. There is not necessarily a consensus as to what the criteria are or the essentiality of the criteria. Nonetheless, I find them very useful in thinking as an educator about student learning. These 5 seem to be pretty characteristic of the scholarship. They seem to be what scholars generally think of as threshold concepts criteria. And I think it's important that we understand the characteristics because a threshold concept is best understood in reference to these characteristics. And so threshold concepts are thought to be bounded, integrative, irreversible, troublesome, and transformative. And I want to take a look at how these criteria function. So first, threshold concepts are thought to be bounded in that they define the terminal frontiers of a discipline. Now, this characteristic has been devalued, challenged, championed in the field of threshold concepts theory. But in defense of the bounded characteristic, researchers have proposed that it really provides a contextualizing function, demonstrating what lies within the discipline and what may lie beyond the discipline. So threshold concepts may be bounded within a discipline in that they have specialized meaning that exists within the discipline. And this may have something to do with sort of the specialized discourse practices that are so characteristic of disciplinary experts. So the example that I have seen in the literature that at least resonated with me is the term deprecate in the context or in the field of computing. It's a term that has meaning that is specific and unique to the discipline and whose meaning may clash with its meaning outside the discipline. My understanding is that the term deprecate means to let an aspect of programming wither away or die. And that concept and that understanding of the concept is bounded within the discipline of computing, and it may clash with its meaning elsewhere. Of course, if deprecate is indeed a threshold concept, it needs to be tested against other characteristics, including integrative. Threshold concepts are thought to bring together aspects of a field of study that students didn't initially see as related. Meyer and Land have written that threshold concepts are integrative insofar as they expose hidden connections that students did not initially view as related. I think we'll see how that kind of works. Threshold concepts are thought to be irreversible in that once learned, it's very difficult, if not impossible, to unlearn them. And I like to use this image when I'm in a room full of people because it's an image that shows both an old woman and a young woman. And if we were all in the room together, I would know whether you could see both the old woman and the young woman. And I don't want anyone leaving here without the opportunity to see both the old woman and the young woman. So I hope you can see my cursor. My panelists, can you see? Okay, so here's the old woman. This is her face, this is her chin, and this is her nose. These are her eyes. And so she's sort of looking downward in this way. And the young woman is looking back this way. So this is her eyelash and her nose, and this is her jawline. She seems to be wearing a choker of some sort, bonnet with a plume. Once you see, oh, I can see Andrew can see. Once you can see both the old woman and the young woman, it's very, very difficult, if not impossible, to no longer be able to see both images. And it is in this way that threshold concepts, once learned, are thought to be irreversible. The next criteria we'll take a look at is the notion of troublesome. Threshold concepts require the acquisition of knowledge that is characterized as troublesome. And I actually love this term because it has broader meaning than merely being conceptually difficult. Depending on the discipline and the context, troublesome knowledge may be tacit, it may be counterintuitive, it may be alien, it may be conceptually difficult. The trouble may arise because the student is defended in some way, resisting the acquisition of this new way of understanding. The trouble can be the result of what scholars have referred to as an underlying game. And I want to take a quick look at what these various aspects of troublesome might mean. So certainly, trouble might stem from a concept being conceptually difficult. And this may be the result of the integrative function. So if the understanding of a threshold concept requires learners to integrate concepts that did not appear to be related to one another, that would be conceptually complex for the learner. Threshold concepts can be troublesome because they appear to be alien or counterintuitive to a previously understood concept or way of knowing. And one example that I read in the literature that I think is pretty powerful is a student who comes to school, to university, perhaps, to study critical ways of examining texts, but who also has the understanding that the Bible or some other religious text is the literal word of God, right? And so asking the student to evaluate a text through a different lens might be very difficult and troublesome and challenging for that student, maybe even painful, asking them to turn away from perhaps a cherished way of knowing. And so that may present this idea of the defended learner, the learner who is resisting a new way of knowing or a concept that is unique to a discipline and really essential for a disciplinary way of understanding. Threshold concepts may also be tacit in the discipline, right? They've become so ingrained in our way of thinking and practicing that we no longer recognize them. We don't reveal them. We may be unable to unbundle them for students. Scholars have really explored the complexity of this tacit knowledge, referring to the way in which sometimes knowledge within a particular discipline rests on underlying paradoxes, inconsistencies, unstated assumptions, and we certainly see that in the law. Finally, the trouble may arise because of specific discourse practices, ways of communicating within a discipline that are unique to the discipline and that are unfamiliar to those outside the discipline. So when a disciplinary expert uses specific language, a specific disciplinary language to try to initiate a new member into the discipline, grasping the concept is going to be difficult for the learner because the parties really aren't communicating. Finally, trouble can arise because some proposed threshold concepts may be more complicated. They may represent not just a discrete concept, but a conception. And researchers have referred to this as the underlying game. So in other words, we know that within a discipline, concepts work together to inform understanding, practice, and theory blend in ways that aren't always transparent to us or to our students. And so by way of example, I sense that a true understanding of precedent may be a threshold concept. In my paper and in this presentation, I will argue that malleability, or the latitude that a lawyer has in expressing a legal principle with varying levels of breadth, is a threshold concept. I think we understand that these work together in our understanding of legal reasoning, argument construction, and those ways of thinking and practicing within our discipline, the underlying game, if you will, of legal analysis, may not be transparent to students, even if we do endeavor to make transparent, discrete threshold concepts like precedent and malleability. And finally, threshold concepts are thought to be transformative, and this seems to be one of the most important or non-negotiable characteristics of a threshold concept. So if we return to Meyer and Land's definition, threshold concepts, again, akin to a portal, opening up a new and previously inaccessible way of thinking about something. It represents a transformed way of understanding or interpreting, without which the learner cannot progress into a disciplinary specific way of thinking. And that leads us to this distinction, or loops us back to this distinction between threshold concepts and core concepts. Meyer and Land and others have described core concepts as conceptual building blocks. They progress understanding of a subject. They are necessary for our students to understand, but they don't necessarily lead to a qualitatively different view of the subject matter. In contrast, threshold concepts do possess that transformative character. So until a student successfully grasps a threshold concept or traverses the portal, the ongoing accumulation of knowledge without that integrative feature may be overwhelming to the student and seemingly unrelated mass of information. And that sort of leads us to this discussion in the literature of the liminal state. So the difficulty in understanding threshold concepts may leave learners in what has been referred to as this state of liminality, partial understanding, referred to as the stuck place. In the liminal state, the learner's understanding approximates knowledge in what has been described as a kind of mimicry or a lack of authenticity. And circling back to acknowledging that effective dimension of learning, threshold concept scholars have asserted that in the liminal state, insights gained by the learner can be exhilarating, but they can also be quite unsettling, causing shifts in identity, sometimes a sense of loss. The liminal state has been described in the literature as similar to adolescence, no longer a child, not yet an adult, perhaps exhibiting characteristics on either end of that spectrum. The liminal state has also been described as unstable for the learner as they move between former and emergent understandings. Nonetheless, once the learner enters the liminal state, he or she is actually engaged with mastery of the material, as opposed to the student who's in the pre-liminal state where understandings are at best vague. And again, I think this idea of the liminal state presents a powerful way for us to remember the cognitive and affective dimensions of learning. Becoming a disciplinary expert involves shifts in identity. This can feel like what has been described as an unsafe journey for a learner as they let go of previously held information or ways of knowing. And faced with this uncertainty and perhaps challenge to their sense of identity, students sometimes construct conditions of safety through this practice of mimicry. This is an illustration provided by Meyer and Land of the various liminal states. It illustrates a student's interface with a threshold concept, troublesome information. So when a student encounters that troublesome knowledge, that knowledge serves as an instigative prompt, challenging a prior way of knowing. As the student enters the liminal state, the integration of information begins, again, perhaps requiring the student to let go of or discard a prior understanding or way of knowing. And this reconfiguration can be perceived as reconstitutive. In the post-liminal state, the student has crossed the threshold and has transformed in a way that's irreversible. And so I think this illustration is useful, but I would caution that Meyer and Land have acknowledged, as have others, that the progression through the liminal state is not necessarily linear, and that our students often migrate, vacillate between these various liminal states, and yet useful for us in thinking about our teaching. So as I said, threshold concepts theory or framework really ignited a lot of enthusiasm with folks in all sorts of different disciplines exploring what might be the threshold concepts of those disciplines. I told you that Meyer and Land were economists, and opportunity cost is sort of the paradigmatic threshold concept that's offered in the literature. It has been criticized, but it is sort of a useful illustration of a threshold concept. Now, big disclaimer, I am not an economist, and therefore I'm going to stay very close to Meyer and Land and others' description of what opportunity cost is and how it functions. The discipline of economics studies the issue of choice, how individuals or organizations choose between limited resources or alternatives. Fundamental to the economist's manner of approaching choice is comparing choice. As Meyer and Land and others have described it, opportunity cost captures this idea that choices can be compared and that all choices, including the choice not to choose, necessarily means rejecting alternatives. So a student who understands opportunity cost has broken free of perhaps a superficial understanding of choice as predetermined or unchangeable. They no longer view simply two sides of a choice, and they're in a position to evaluate more than just the immediate consequences of a particular choice. Going a little further, and I am going to have to quote here, because again, outside my element, not an economist, Meyer and Land and others have explained that opportunity cost, the value placed on the rejected option by the chooser, is the obstacle to choice. It is that which must be considered, evaluated, and ultimately rejected before the preferred option is chosen. Opportunity cost in any particular choice is, of course, influenced by prior choices that have been made, but with respect to this choice itself, opportunity cost is choice influencing rather than choice influenced. And once a student understands this as a valid way of interpreting the world, it fundamentally changes their way of viewing their own choices and evaluating other choices. It serves as a tool for them to evaluate other choices. They begin to think like an economist. So this slide illustrates threshold concepts that have been explored in other disciplines. It is just a sampling from a 2008 Meyer and Land compilation titled suitably, Threshold Concepts in the Disciplines. So as I said, when I first encountered threshold concepts theory, there wasn't much written about threshold concepts in law or in legal education. I did find a couple of newsletters, essays that suggested things like precedent or the corporation as person as potential threshold concepts. I also found two papers, both by Australian researchers, that proposed very similar ideas, thinking like a lawyer or legal reasoning as a threshold concept. Interesting papers. To me, thinking like a lawyer seemed too broad, seemed more like a threshold conception. I have no doubt that understanding how to think like a lawyer or to engage in legal reasoning requires a student to understand lots of core concepts and concepts that I think we could characterize as threshold concepts, but it seemed broader than what I was thinking about. So in my paper, I explored this notion of malleability, and this is the label that I chose, and we might contest whether that was the most intuitive label, but what I mean by that, again, is the latitude a lawyer has in interpreting prior authority, articulating it broadly or narrowly. As legal educators, we routinely ask students to cull legal rules from a series of cases and then to try to synthesize those rules into an overarching principle that can guide future disputes. In doing that, we sometimes ask that they test that developing principle back against prior cases, and that test sometimes reveals to them how far the law can be stretched or constricted within both an ethical and reasonable zone of interpretation. And certainly we all realize that there is an ethical and reasonable zone of interpretation associated with this concept of malleability. We sometimes explain to students that the way in which they elect to do this, articulate the law broadly or narrowly, will be informed by their purpose. Are they engaged in predictive analysis, persuasive analysis? Are they preparing for a Socratic dialogue in their doctrinal classes? What is their goal? But I think that in this context, malleability is a threshold concept, and I'm going to try to defend it against these characteristics. I think malleability of legal principles within the context of legal reasoning and advocacy is bounded within our discipline. It is a concept that informs how law-trained individuals approach the law not as a static set of rules, but as a sort of framework to scaffold legal argument. I think malleability is integrative. It brings together other concepts within legal analysis, concepts like jurisdiction, precedent, rule of law, stare decisis. Understanding malleability requires students to sort of simultaneously recognize the certainty of law in terms of notions like precedent, rule of law, credibility of legal institutions, alongside the essential malleability of legal principles. I think it's a concept that's irreversible. I had that aha moment in law school. Once a student understands that the law can be approached critically and with a degree of latitude, it's difficult to unlearn that concept. Malleability is also arguably troublesome and transformative. Students often come to law school with the understanding that the law represents a set of rules that govern society. And the idea that these rules might be malleable can be counterintuitive, alien, even objectionable to students. Understanding that fundamental uncertainty about what the law is or may be can be very conceptually difficult for students. They may experience this turning point as challenging and unsettling. Once they understand the concept of malleability, however, I think their understanding of law and of legal reasoning is transformed. They'll no longer view the law as a fixed set of rules, but they'll appreciate really the role that the advocate plays in shaping legal argument. I think we see our students in the liminal state. I think we can see instances of mimicry in their papers or in their responses in a Socratic dialogue when they attempt to formulate arguments based on a prior authority on either side of the issue. The students with a superficial understanding of malleability or an emerging sense of malleability may stretch the law far too far or may constrict it far too narrowly. They may use terms inaccurately. They may misunderstand the relevance of certain principles. So I think we can see them in the liminal state of understanding this proposed threshold concept. So if I've presented a plausible argument that malleability may be a threshold concept in legal education, what does that mean? What are the implications of identifying threshold concepts or malleability in particular as a threshold concept? In the paper, I tried to differentiate between what I sort of viewed as threshold concepts that permeate the discipline, like malleability, from ones that might be rooted more in a specific legal doctrine, like the corporation as person. For malleability, a threshold concept that I think permeates the discipline, I think there are some practical implications. If we can form a consensus around malleability or some other label for this concept that I'm articulating, I think that would provide a powerful lens for us for viewing student understanding across the curriculum in both doctrine and skills-focused courses. Once malleability is defined as a threshold concept, professors could try to make it far more explicit to students in their classes. I think we do this to a degree in legal writing. It is, after all, a legal analysis course. I'm not sure we use terminology that's accessible, clear, transparent. I'm not sure malleability was the best label. It was the one I chose. In doctrinal classes, we are exploring malleability when we engage in a Socratic dialogue, asking students to apply a legal principle to ever-changing sets of hypotheticals. But we could perhaps make the process of malleability more, or the concept of malleability more explicit or transparent in that dialogue. Faculty could coordinate instruction on threshold concepts, including using consistent terminology, assessment techniques, development of appropriate benchmarks for ushering students through this necessary portal. So I think there are pedagogical opportunities, curricular opportunities associated with identifying threshold concepts. I have found this to be a really, really interesting, intellectually engaging topic of discussion. Over the years, I've chatted with folks about what threshold concepts might exist in law, in legal writing, in other disciplines. And in fact, a group of legal writing faculty have gathered together to try to articulate and memorialize the threshold concepts of legal writing. We are emulating a similar project that was conducted by writing studies professors who gathered together to articulate the threshold concepts of writing studies in a text called Naming What We Know. So we are working to try to articulate and memorialize the threshold concepts of legal writing. I'm working with Christy Schoen at Georgetown, Linda Berger from UNLV, Kirsten Davis from Stetson, Ruth Ann Robbins from Rutgers, and David Thompson from Denver. And so we have been working on this project. We have stumbled along a bit during the pandemic, but we are returning to our efforts. We have some other people in the legal writing community who are involved, and we would be thrilled if anyone out there thinks this is an interesting topic and would like to work on that project. Please reach out to any of us. Now that returns us, as it should, to Judy's work on student learning. Again, I have my trusty tabbed text here with me. In the introduction to her text, The Tao of Legal Writing, Judy observed that after many, many years of teaching legal writing, she discovered that, quote, many of the concepts most central to effective legal writing do not lend themselves easy to explanation. Couldn't agree more. In the quote that's featured on the slide from the Tao that Judy selected, she challenges us in the way of the Tao and to question, do you have the patience to wait till your mud settles and the water is clear? Perhaps, just perhaps, threshold concepts theory might help us study the mud that cloudies the water for our students on their journey to become disciplinary experts. So that concludes my remarks, but I would very much like to hear from you all. I think you can use the question and answer feature. Push back, I'm ready. Or don't, that'd be fine too.
Hi, everybody. This is Andrew Carter's voice. Do take advantage of the Q&A button. I will be reading the questions to Mel, and we'll proceed from there. So the first question, it's really a comment. This is from Charles Cayeros. Love your photos. Hope you share the PowerPoint. Melissa, do you have a response?
I do have a response, and I have to thank one more person, Rebecca Lutkenhaus, one of our library faculty members, helped me with some of the images. I have used images, but I like to make sure that I am using, copyright royalty-free images. So she is the one who helped me with many of those images, and I want to thank her audibly.
This next question is from Kimberly Holtz. This is great. How does this view, preliminal, liminal, post-liminal, the stages of commanding a threshold concept, compare with the hierarchy of competence, unconscious incompetence, conscious competence, unconscious competence, and unconscious competence, the stages of learning?
Well, I wish I could pass the mic to Kim Holst to ask how she thinks that it compares, but I think that there is definitely, these ideas resonate with one another, particularly this idea of unconscious competence and the notion that there are ways of thinking and knowing within any discipline that we have forgotten as disciplinary experts. We may have forgotten the aha moments. We may not have even experienced them in law school as aha moments, but we want to dig deeply into trying to figure out what it is that students indeed need to know that we may not be making transparent, and we may not be making those ways of knowing and those concepts transparent to our students, because as disciplinary experts, we have achieved that level of unconscious competence. So I think that there is, there is some certainly interplay between those ideas. Great question, Kim. Feel free to put in the chat or the question and answer box how you think they relate to one another. And I'm glad you're here.
We have another comment from Kathy Stanchi that it was an amazing presentation, but she had to step off. I am going to take an opportunity to ask a question as the keeper of the queue. Mel, so as I was reading the paper and obviously listening to the lecture today, I think I endorse this notion that malleability is a really critical threshold concept for our students. And I think I've been teaching it, like you suggested, many of us have in our legal writing classrooms. And I've been teaching it probably with my introduction to legal realism, or perhaps just a very basic critical legal studies. And this idea that it's not just some sort of objective process of dispassionately applying concrete rules to facts and we get output, but there are other things going on, particularly with judicial decision-making in terms of the emotional baggage, policy preferences that would inform the decision-making process. But that obviously has to be facilitated by this concept of malleability. There has to be the availability of more than one answer to the question before you can have these other implicit biases influence the decision-making. I'm wondering if you've thought about that connection in your thinking about this.
I'm not sure. Can you?
I may not, well, we can presume that I did not quite explain that, but there's the theater of legal formalism, which I think is what you're trying to combat with this threshold concept of malleability, that it's not as simple as inputs lead to outputs.
Right.
And so what in my classroom, I teach that effectively as legal realism, right? It was the anti-Langdell view, but legal realism, the predicate to that is understanding the malleability of legal concepts, which then allow the expression of these these other inputs on the human endeavor of judicial decision making.
Yeah. So I love that, because I think what you're doing is you're adding another layer of complexity. Malleability may be a threshold concept within a threshold conception, where we import those additional layers to legal reasoning, or maybe not. Maybe those additional inputs are just further inform our disciplinary understanding of the fact that the law is not static, it's flexible. And I do think that I mean, certainly, and maybe I'm alone. Maybe it was just me who went to law school and thought, wait, what? I thought that the law was a rule and I'm a rule person. And what do you mean that it can be all sorts of different things? And I think you're right. I think there's, I'm not sure. I'd have to think more carefully whether malleability maybe is the jumping off point for where you then take students, or whether we haven't really achieved malleability until we've included those other ways of thinking about the law. So I think that's really interesting. I guess one thing I'd be interested in terms of, your reaction. I had a long conversation when writing this paper with one of my colleagues who teaches con law, and he really did not like the label that I was choosing. And I looked at some other labels, but they seemed to have different meaning that I wanted to sort of stay away from. So I've always been really interested in people offering maybe a more intuitive, maybe a more descriptive way of describing what it is that I'm talking about.
Well, there's more. I would love to continue this conversation with you, Mel. There are other questions in the queue. This is from Craig Smith. Malleability undermines an expectation of right and wrong. Might that necessarily suggest a set of companion threshold concepts regarding legal reasoning based on legitimate rules, evidence, and process?
Yeah. Again, I wish we could just pass the mic to Craig Smith, because I'd love to hear more about what he has to say about that. And I think that the first sentence of the prompt is really interesting, because it really does show how this concept of malleability challenges prior ways of thinking about the law. We come to law school thinking the law tells us what's right and what's wrong, and then we tell students, well, it depends, as we so often do. That can be quite troubling to students, and yet there are rules that are more definitive. And so, yeah, I'd love to hear what Craig had to say about a companion set of threshold concepts regarding legal reasoning, because malleability doesn't necessarily work everywhere in the law.
All right, with that, the queue is complete. Unless there are any last questions, Mel, thank you for this. I will take the liberty of announcing that this would be the end of the second annual Judy Stinson Lecture Series here at Arizona State University. We look forward to seeing you next year, all those in the audience, and join me in a loud round of applause that Mel can't hear to thank her for today's excellent presentation.
Thank you all. I appreciate it.